Hi everyone, it's Amanda Riedling again, and today I am making a video about why you should not add your child to the deed to your home. I can understand the temptation to do that if one of your goals is to avoid probate in the event that you were to pass away, but I'm here to tell you there is a much better way to do that that continues to protect you and your interest in that home. And so one of the first downsides, and again, I understand that there are reasons why people want to do this, and sometimes it works out great. But in my opinion, the negatives to this strategy greatly outweigh the positives. So the first thing is when you add someone to the deed to your home, you are, at least in the state of Georgia, you are gifting that portion of your home to that person. You no longer completely own that home. You can't sell it without their permission. You can't mortgage it or get a home equity line without their permission. You give up all that control. The second reason is for gift tax. Anytime you gift someone over $15,000 of value in anything, in total in a year, you have to report that to the IRS with a gift tax return. And if you don't report it to the IRS, we all know consequences that can come from that. Another downside that comes with it is sort of going back to that person now owning part of your house. They own it for all purposes. If they get sued, if they get divorced, anything like that, your home is now at risk to that person's spouse, that person's creditors, everything. So there's just a better way to do that. If you are looking to avoid probate in the event that you pass away for your real estate, in Georgia, you can create what's called a revocable living trust, and then you title that home in that trust. That trust then survives your passing. If you pass, that trust still exists. Your home is already in it. And the next trustee listed in that document can immediately go do things with that house outside of probate. So please take this as a cautionary tale. We've had many clients who have done this and regretted it because they couldn't get the other part of their home back. Or maybe they put their minor child on their deed, and that opens a whole other situation where minors legally can't give it back. Once they turn 18, they can choose to do that. But in the meantime, if you want to sell your home or do anything with your home, that child owns that portion of the home. And you have to have a conservator appointed by the probate court to get permission to do anything with the home. And then if you sell it, you've got to put that percentage of value that child owns in a bank account for them, even if you paid for it. So please just be careful anytime you are doing anything with a title to your home. Please talk to an experienced estate planning or real estate attorney before you do that. Again, I'm Amanda Riedling from the Georgia Wills Trust and Probate Firm, and I hope you learned something. Thank you.